Good day to you. This is Graham Paddock and I welcome you to another Paddocks Club video tutorial. Today we'll be looking at repair and maintenance of common property and dealing with some misconceptions. Let's just go back to the beginning on this one. There is a statutory obligation on the body corporate to maintain the common property. If the subject of a repair is part of the scheme's common property, the body corporate must carry out and pay for the repair. Section 37(1)(j) of the Act says that a body corporate's mandatory functions include, this is important, properly to maintain the common property, including elevators, lifts, and keep it in a state of good and serviceable repair. That's an unqualified obligation. The body corporate must look after, maintain and repair, replace where necessary, all parts of the common property. Now, the Act also provides for various rights of recovery in regard to exclusive use areas and future development areas. When the body corporate carries out the work and pays for it, it must recover the attributable costs from the person who has these special rights, either the exclusive use rights or the future development rights. So if the defective part of the common property falls within an exclusive use area or a future development area, the body corporate is still obliged to carry out and pay for the repair, but it must recover the costs from the person who holds those special rights. There is an exception for geysers, these installations that provide hot water to individual sections and are often outside the sections, for example in a roof space or outside where they are technically common property. Now, Prescribed Management Rule 68(1)(7) deals specifically with this and says where a hot water cylinder supplies one or more sections, the owners of those sections, the one or many, must do and pay for all the repairs and maintenance, replacement included. I want to touch on two common misconceptions. The first is that if common property exists only to serve a particular section, such as a water pipe that sits outside the section but is only taking water to that section, then the owner of the section must pay. That is wrong. There is no basis in terms of the Sectional Titles Act or the Prescribed Management Rules to suggest that because a piece of common property equipment only services one particular section, the owner must pay. That's not the case. The other misconception is that if damage to common property is not actually the body corporate's fault, then it doesn't have to pay for any consequential loss. I've seen this come up quite a lot, such as when roof tiles blow off and there's water damage to the top section, probably goes through the rhino board and down into the thing. It's not about whether the body corporate failed to do anything. It's not a question of apportioning blame. The fact is that that part of the common property, being the roof tiles in this case, they failed. They didn't do what they were designed to do, which is keep water away from the section. And the result of that is that the body corporate must repair, but the loss caused as a result of that failure is also for the account of the body corporate. I hope that this assists you, and I would welcome any further discussion in the discussion forum.